Good morning. The question of adoption always plays vital role when we conduct or defend the civil cases of for disputed property dispute. So therefore, what is essential ingredient for valid adoption and how far the adoption would work? Apart from that, the judgment which I am going to share also speaks about after adoption, the adopted father becomes sannyasi. Therefore, the court said it is civil death. Then they allowed his adopted son to own the property. Judgment seems to be single judge, so it's a very good judgment which is likely to be appealed, and finality will be from Supreme Court. Because the judgment also discuss about 1, 2, 3, 4, 5, 6, 7, 8 Supreme Court judgments, but I do not think was there any direct answer for the sannyasi being treated as civil death, deemed death. See, the judgment AR 2023, Allahabad 222, Param Jota was the Deputy Director of Consolidation and others. The land seems to be belonging to father Mahadev. But the consolidation proceedings when commenced at the village, the name of Mahadev and Bola, adopted son, was available on revenue record. Therefore, the petitioner filed an application that she has got half share in Kathas number 9 and so many, that 2, 3, and she want half share. Objection was Yogandhara that he was duly adopted Bola, who later became sannyasi. The consolidated officer Balia rejected the objection filed by the lady and allowed objection filed by the respondent for Bola, and he became owner of the property. Then appeal was prepared by settlement officer, consolidation. So that was allowed. Thereafter they went to revision before the Deputy Director of Consolidation, and Deputy Director of Consolidation accepted the same. Then they went to writ petition, filed single writ, that was writ, affirmed the revision petition, revisional authority, Deputy Director of Consolidation. They have discussed the major conditions which required for validity of the adoption. Section 11 of Hindu Adoption and Maintenance Act. Number 1, that should be the adoptive father and adoptive mother must have a son living at the time of adoption. Then if it is a daughter, she must have daughter at living time of the adoption. If he is a male, the adoptive father should be 21 years older. Then if he is a female, the adoptive mother must be 21 years older. So the basic requirement is that the father who adopts son should not have son or son's son or son's son, grandson or great grandson. Same with the living, if she is a daughter, Hindu daughter or son's daughter. This was not looked into by the women empowerment parties here, because this provisions is not properly amended at par with Hindu Succession Act 2005. same child may not be adopted by two or more persons. This is what they say. There should be transfer of the child from one person to other. Then they say the datta homam is not essential to the validity of adoption. Here in the given case, a registered adoption was there. Therefore, the section 15 says valid adoption cannot be cancelled. Here the other party seems to have filed an affidavit attested by notary as if this adoption deed was cancelled. Registered adoption deed cancelled by power of attorney, affidavit attested by the notary public. Then section 16 was also discussed that the registered document should be treated as valid document unless and until it is disproved by all discussion. So therefore the judgment may enlighten you how to adopt a child, what are the requirements for adoption child, and also the validity of registered adoption deed. Datta homam is compulsorily not necessary, solemnization, but handing over the child is necessary. Then question arises if it is registered document is validly acceptable. Then the question arises, all these authorities held that the father of the Bola, Mahadev, became sannyasi, therefore civil death. Therefore his son, being illegal, is entitled for mutation of the record. This is what I am placing before you. Let us wait for appellate judgment or Supreme Court vouch. So far that area of Sanya is concerned. That's best to say.